So hello and welcome to the latest in URM's webinar programme, Data Subject Access Requests, or DSARs for ease, so I don't get too tongue-tied as we go through this webinar. A nightmare for privacy professionals, or are they? My name is Lisa Dargan, I'm a director here at URM, and I'm delighted to be joined by Rachel Salter, who I'll introduce to you shortly, who's going to be walking you through the subject of DSARs. So we've got a really packed agenda that we're aiming to address today. We're going to start with, just so we're on the same page, what is a DSAR? We're going to look at some recent breaches and ICO actions very briefly, just to put into context why this is such a hot topic and the ICO's approach to it. We're going to look at the legal requirements you need to comply with, the key steps, how to appropriately consider context, and as Rachel will explain to you, this is vitally important. What you can do if you believe the request to be vexatious or excessive or way over the top. What are derogations? I don't even know what that word means, so hopefully Rachel you can explain that to me and how they apply, how to apply them. Redacting other personal data, i.e. not the data subjects, how far do you need to go? Potential post-disclosure issues, top tips, and then a webinar offer. Now, the recording of this and the slides are available, so if you can mark on your feedback form at the end of the webinar that you would like to receive a copy, we can share those with you. So just very briefly, for those of you that aren't familiar with URM, who are we and why we're doing this webinar today? We've got over 19 years experience. We're tipping into our 20th year next year. And we've been working with data protection since our inception in 2005. We take a holistic approach generally around information security, data protection, cyber security, matching our expertise with that of our consultants who've got a lot of experience, probably sitting on the side of the fence that you are, and also working as consultants. What makes us different? As you'll find out from Rachel in a moment, we have a passionate team of people who really care about the subjects that they are experts in and really want to help you and help make your lives simpler whilst complying with legislation. So let me just introduce you briefly to Rachel. Morning, Rach. Thank you for joining us.
Good morning, Lisa.
So Rachel's been involved with data protection since 2010. As well as being a senior consultant, Rachel's acted as a DPO for a number of organisations. She's a very accomplished trainer, and one of the offers we've got from here is to attend one of the training courses. Rachel's worked with UK and EU GDPR, global legislation, particularly in the US and parts of Asia, and is our team leader in terms of DSAR redactions, and hence is why so strong on today's subject. So Rach, let's start with, let's just go back to basics so we're all on the same page, because I do get slightly confused by this. What is a DSAR?
Okay, so a DSAR is basically a request made to a company, and that request comes from someone who wants to know what personal data is being processed about them by that company. It's not always necessarily badged as a DSAR, so they may not use the legislation. It doesn't always necessarily need to be done in writing either, so it could just be an email, a telephone call, someone could just mention it in passing, I want to see my information, or I know you have a copy of, or something along those lines. They don't necessarily have to mention the word DSAR or data subject access request. So you need to be aware for listening out for key terms to be able to recognise one when someone has a discussion.
So is this, right, so this time of year, I am bombarded by all sorts of organisations that I didn't think I'd ever approach to tell me it's Black Friday and look at this amazing offer. So when we talk about a DSAR, is this when I go to organisation X and say, give me what information you've got on me? Is that so that's my right to ask for information, what information's held on me or what personal data people have got? Is that what a DSAR is?
Yeah, absolutely. So basically, if an organisation processes your personal data in any way, you as the data subject have the right to make a request under Article 15 of the GDPR to have access to that information they process about you. That could be your bank, it could be the GP, it could be a credit card company, it could be anyone who processes your information down to the dentist or something like that. And it's where you ask to see what copies of information they hold about you.
And do I have to What do I do? Do I ring them up? Do I email them? How can I ask for this? Could I just ring reception and ask them? What do I need to do?
You absolutely can. So with the inception of the GDPR, it's made the way to make a request so much easier. Historically, requests used to be in writing. Now you can literally pick up the telephone and say, I want to see a copy of, or you can walk into reception and say, I want a copy of my HR file. I want to see a record of this. I'd like a copy of this email. So it can be a verbal request, it can be an email, you could even post it on a company's social media. So the way to communicate this now is so flexible, it's made it so much easier to facilitate a subject access request.
So the new legislation, if I remember rightly, it's more about my rights as an individual, isn't it, than an organisation's rights. So I can ask for this in any way, and I don't have to ask to speak to data protection team, and I don't have to say, I am submitting a DSAR, can you give it? I can just say, can I have?
Absolutely.
And as an organisation, you've got to recognise that as a request.
Absolutely. So most individuals will not know the official terminology. They won't write a request that says under Article 15, I am exercising my rights.
Yeah.
They are not going to understand that. People are not data protection professionals, but they are now more information savvy. The legislation allows for them to make a request without using the legislation or without formalising a paper request. So this is why it's really important that everyone in your organisation can recognise terms or words that they say, or at least thinks this could be something around someone asking for information. I should send this to our data protection team.
And what are my rights to see what you hold? I mean, what are my rights? Can I to get copies of it?
Yeah, so depending on what you ask for, the data subject rights under Article 15 allow you to have access to information that is processed about you. You can ask for a copy of that. You can ask for the types of data set that they are. You can ask who that organisation has shared that information with. The GDPR was all around giving back power and control to the data subject, and this is one of the biggest drivers by allowing data subjects to ask questions around the information that organisations are processing about them, so giving the power back to us as individuals.
Okay, so just to put this into some level of context, am I right in saying that this is a key focus currently for the ICO?
Absolutely, yes, and failure to comply is huge at the moment for the ICO. It's a real target area. So this is why, you know, organisations, it can be quite a stressful time when they receive something like this, because the ICO has there's a very tight time scale on how quickly we respond. We'll cover that, I'm sure, on how quickly we need to get this response back. So it's quite a lot of pressure for an organisation when they receive one.
So I think we've got a couple of slides at the moment. These are all that have occurred or been the subject of an ICO investigation within the last couple of years, and is it just a one-off? Did the ICO re-audit? What's the approach?
So what generally happens with the examples on the slide, the ICO come in and audit an organisation. They'll assign a caseworker to have a look at the evidence around non-compliance, and the ones on the screen that you can see, it's failure to comply on time. So not meeting deadlines or not complying in full, or feeling like it's not a fully completed subject access. The caseworker will review that and ultimately will give the organisation time to put corrective measures in. So catch up, start to be more compliant, which of course is very tricky because the world doesn't stop, business doesn't stop. So if you had 9,000 outstanding DSARs, that's going to take a huge number of disclosure officers to turn those around while still receiving new ones coming into the business.
So can I turn around and go, look, we're too busy, we're too stretched, I don't have enough people to respond? Is that an acceptable excuse?
No, absolutely not. And it is being used quite widely as well. Organisations are saying we just don't have the capacity to process this. But of course, data subjects have the right to complain to the Information Commissioner. So of course, the ICO, this is just compounding the problem, because the ICO then will squeeze them tighter and say, but you have to comply, it's the law. It's a breach of the law by not complying.
Got it.
So they'll have gone through a process. They will now be about to be re-audited. Have they put in those measures? Have they got better? Are they now compliant? So the ICO will be reviewing that as we speak, and we should get some updates on those shortly.
Okay, and most of them, so I know that we've kept a close eye on this, and most of them we've looked at are just not replying on time, isn't
Correct.
it?
Yeah, failure to comply in the calendar month. 30 days is quite tight.
Yeah.
It equates to 20 working days. If the requester has 10,000 records in your organisation, that's quite a drain on your resources.
Wow, okay. So I suppose the key thing that we need to take away, it is a key focus for the ICO in terms of DSARs and responding to DSARs. So I've now received I've received a request. It's come in on social media. My organisation's really savvy and requested that. What do I need to do now?
Okay, so the minute you recognise a DSAR, it's really important that you acknowledge it. The data subject needs to know that you have received and accepted that they have made that request, that you've recognised it. So there is a number of administrative steps that you need to take. So you would need to contact the data subject and say, thank you for your request, we have that. Depending on what you know about that individual and what your relationship is with that individual will depend on whether or not you need to verify their identification.
So I need to make sure that they are who they say they are.
Absolutely, because Unfortunately, it is quite common for individuals to pretend to be someone else and make a request on someone else's behalf.
Okay, so if it's an employee, then I probably know who it is. But if it's just a member of the public, has the clock started when I send an email to ask them to verify? And how do they verify who they are?
Okay, so the clock doesn't start ticking until you have verified the request. It has to be a legitimate request. Sometimes a request will come in and you could have a conversation with the data subject and it never actually turns into a full request. So it may be that they have used the wrong piece of legislation, or they're asking for something that they're allowed to have for another purpose outside of the legislation. So if in terms of verifying someone's identity, it's really key, it's really critical, because unfortunately individuals have been known to request data that's not actually theirs. Maybe a partner, maybe an ex-partner could do that. Now, you've got to be very careful here. It's a real balance, because what you don't want to look is like you're stalling on the request, because individuals will see you pushing back at them as a delay tactic. Which is quite common. A lot of organisations do this to try and slow down the process and give themselves more processing time. But something as simple as a driving licence or a copy of a passport to verify that the individual who's making the request is who they say they are. Like you said, if it's an employee, you are likely to know who that person is. They may use their employee number in the request. They may be using their personal email that you have on their HR file, so you can correlate that request. Depending on that relationship will depend on the need to actually verify some ID. If you're just a random customer that you wouldn't automatically know, you are likely to need to supply something like a passport or a driving license that correlates with your name and address for you to then say, okay, the clock has started now, we've verified this as a legitimate request, then we're on to the next steps.
So the clock, the 30 days doesn't actually start until I've verified.
It's a verified request.
Okay, so I've acknowledged them, they've verified, I'm like, yep, the clock. Okay, so the example you gave, like a partner, can I say, oh, I'd like to know everything you hold about me and my partner, or can I only ask for my own information?
Okay, so you can ask for both pieces of data, but what we would expect to see from that is the consent of the other individual. So for example, let's say think about some of our housing friends, our social housing friends. It may well be you have a joint tenancy and both tenants want to see a copy of some information that the housing association holds around them. Now, if the tenancy is in joint names, we would expect to see the consent of both individuals. And once we have that, usually it's a letter from one or an email from one, and then maybe a secondary email from the partner that says, I'm authorising my partner to have copies of this information to do with our tenancy. So you would need to see the relevant permissions around that, unless someone has got something like power of attorney, for example, or another legal requirement where someone's acting on someone's behalf. So it may be, I need to see all my mother's tenancy information.
So unless I've got good reason and unless I've got consent from somebody else, I can only request my own data. Okay, so I guess the question is, as if I think someone's asking for information that's like, really, this is just spurious, can I say no? Do I have to reply? I think back in the day, I used to be able to charge them for it. Can I still charge them?
That's right. So historically, before the GDPR, a subject access request, because it's not a new thing, I think it's just we're taking it more seriously now due to the fines and obviously the ICO's focus on this as a key priority. Historically, you had 40 days to process a subject access request, so we've reduced that by 10 days. And bearing in mind, it's not working days, that's a full calendar month. And there used to be a fee of £10. Now, £10 is not a huge amount of money, but it did ultimately stop a lot of people from putting in a request, because you'd have to write a check or a postal order and send that to the company. That all takes time. We live in a digital age, people want things quickly. So now the fee has gone, there is no charge at all now, unless, and there are some circumstances where you can charge a small fee. For example, if someone makes repetitive requests, or if you sent out a request to someone and they lose it. So let's say you send a paper copy and it's lost and they request a duplicate, then it's reasonable that you could charge a fee for the re-administration, the printing and the postage, for example. But that's not standard and it cannot be a blanket approach. So be very careful around charging large numbers. The ICO will take a view on what they think is reasonable for something like printing costs.
Okay. And have I got to reply?
Yes, you do. So you have to legally acknowledge the request. If you have the ID, so most people who know about this will send in a request with valid ID to stop you from stalling, so that there is no reason for you to refuse that request. You must do your initial research at that point. You must, if you ignore that, if you pop it in the in tray or the top drawer or the bin, then that person is likely after 30 days to come back to you and say, I was expecting this on this date and I've not had it. At that point, if you haven't complied, they have, the data subject will and has the right to complain to the Information Commissioner. When GDPR came in, there was quite a number of organisations filing it in that top drawer and hoping it would go away, a bit of a head in the sand kind of attitude towards it. But the ICO was all over that and needed to make an example of individuals quite quickly. And as, of course, like say you said at the beginning, this is a huge focus for the ICO. It's a breach of Article 15. It's very important. It's what's at the core of the GDPR. So they're all over this.
Got it. Okay. So just to kind of, I suppose, summarise and look at this in a bit more detail. In terms of complying, when do I not have to comply? So when can I say, no, I don't think so? So you've said about if I haven't got consent, is there other kind of circumstances when it would be sensible not to?
Yeah, so if someone makes a request and there is an exemption within the GDPR, and an exemption is basically a reason not to do something, where something is exempt from the rules of the GDPR.
And we're going to cover that.
I think we are going to cover that in another section, but just there are some circumstances sometimes where we can say no. For example, if you were a criminal and you put in a subject access request to your local police force and said, I want all the information you hold about me, that local police force is not going to release the intelligence they hold on a criminal. So there is an exemption around crime prevention that they are allowed to apply to say, no, I'm sorry, you can't have that information. And I think we're going to cover exemptions a little bit later on because they're quite critical. You understand what the key ones are, because yes, you can say no for some reasons. National security, we're not going to, the government is not going to release information around shift patterns for security officers at the Houses of Parliament. It's not going to happen. But the majority of the time, 9 times out of 10, you will be forced to comply with this if it is a valid request and it is being sent to you as an organisation in the spirit of Article 15. Because I think we're going to touch on vexatious requests where people might want to cause or trip up your organisation. That's not in the spirit of the law. So again, there's an exemption in there that where we can push back and say no.
Okay, and so the Act says you don't have to comply with a DSAR in terms of by disclosing information which identifies somebody else, unless one, they consent, or it's reasonable to comply without their consent. And when would that be reasonable to comply without?
Okay, so I'll give you an example of that. So often information, when you're disclosing it to an individual, it could contain a third party, for example. So let's say an individual in an organisation has a grievance with another member of the team, and a senior manager's had to bring both of them in for a formal meeting. That is a documented meeting. Both people were in the room. It's minuted. If one of those individuals puts in a subject access request, you make a decision around, would we actually remove the third party data of the person that was sat in the room at that time giving that information? Because A, it's already reasonably known to the data subject. They know who was sat in the room that day. They know what was said and that it was minuted. So they know that document exists and they know the third party that was involved in that. So we are able to take a view. It's not a blanket approach, it's a case by case basis as to whether we would or wouldn't leave in that third party's information. Now, some organisations take a blanket approach of never leaving in third-party information because sometimes the data subject could take that document to social media, which would then mean that other third-party person's information is suddenly available to everybody. So if, for example, a housing officer may have had a discussion with a tenant, if that housing officer's information is suddenly leaked onto social media, they can be hounded, they can be harassed, they can be contacted, email addresses can be worked out, people can be targeted. So you've got to be very careful to protect that individual. When you're making a decision around leaving in third-party information, what is really important is what is the impact on that third-party person?
Yeah.
So if leaving someone's information in is going to cause them some significant damage and distress, you absolutely would make sure you removed it.
Okay. And do I have to ask that third party if I can release their data? So do I have to get their consent?
So no, you don't have to. There is some really great guidance around this on the ICO, around whether you should or shouldn't. Firstly, you should be taking into consideration, can I ask the third party person, is it okay to leave your information in this document?
Yeah.
The likelihood is 9 times out of 10, they're going to say no, because they don't want their information to be released publicly. You know, people do all sorts of things with this information when they get it. If they say, no, I don't consent to you doing that, you as an organisation need to consider what's the implications if you decided to overrule that individual's consent, because you can take a view on that. What would be the implications on that third party person?
Okay, so we've just been asked, what if that person's, say, fortunate enough to be on a cruise ship traveling around the world, and you can't get hold of them and you're not going to be able to respond within the deadline? What can you do at that point?
You see, for me, I would take a view on the impact on that individual.
Yeah.
If it's such low impact that actually it's just someone's first name, then why would we, you know, what is the impact? Because if your name is John Smith, for example, that's quite a common name. It could be millions of John Smiths. So, you know, you take a view on what's the detriment to that individual if you released it. For me personally, in my experience and having done thousands of these, I would say it's not necessary to leave it in. Let's remove that.
Yeah.
Let's redact that from the document and let's take it out. Sometimes you need to leave some context in there. I think we might touch on a little bit of context because it is important not to over redact documentation.
Yeah.
But I think I would take a view, I can't respond in this timescale, I can't get the consent. Let's err on the side of caution and let's remove it.
Got it. Okay. And I think it's worth pointing out, you did tell us the ICO guidance of May 2023 is it's available on their website.
Absolutely, yeah, it's great guidance. It does walk you through scenarios.
Okay, so you talked about the timescale, 1 calendar month. Now, I'm slightly confused by this. I can pause the time limit?
So you can pause the time limit if you need to go back to the data subject for some clarity.
Okay.
So I always try where I can to encourage a conversation between the disclosure officer and the data subject, because very often the request is broad.
Yep.
I want all my data. I want to see everything you have on me. That could be huge for an organisation.
So hang on, let me just clarify. Are you encouraging to have a relationship with, you know, to open up that debate and have a relationship with whoever's put that request in?
I always find that the best and most positive outcome for any data subject is to give them what they want. But what you've got to establish very quickly is, what is it they actually want? So why not try and say to them, okay, we have your request. It says you want everything. Can we drill down into that a little bit? Because this is going to make me get your information to you faster, more efficiently. We'll meet the deadline if we know what you need. So usually when someone puts in a subject access request, they're upset with something.
Yeah.
Generally, a subject access comes out of a negative experience. Maybe they've been part of a redundancy or a restructure in an organisation. Maybe they feel they've been targeted by someone in the organisation. So they want to know why me? So they put in a request that says, I want everything. But ultimately, when you have a conversation with them, generally what they want is something quite specific and maybe only between a couple of individuals. So they may want to understand, I was part of this restructure. I want to understand the 3 critical people that were involved in that and the choices that they made. I want to see all the information they had around me. I want to see the conversations they had where I was discussed or my role was discussed. If you can narrow that DSAR down to something very specific, you can action that much quicker, meet the deadline, and actually get to the data subject what they really want from you.
And whilst I'm going through that process, my time limit pauses. So my 30 days, I've gone back to the data subject to try and clarify. I can pause that ticking clock.
Ultimately, if you need further clarity, if it is not clear, or for example, if someone makes a request and you can't find them.
Yeah.
So Rachel Salter makes a request to an organisation, you do all your key searches on your systems and you can't find a record of her. She didn't work there, she's never been a customer. Yeah. I don't understand why, where's this relationship? You can go back to the data subject and ask for clarity. So at that point, you're going to pause the clock and say, can we just get some clarity? At what point did you have a relationship with this organisation?
Got you. And can I extend that time limit? Is there any, can I?
If you feel like you're not going to make the deadline.
Or if there's too much, there's a lot of information that if I can't scrape it out the systems quickly enough, is there any opportunity when that
Okay, the law
that
does
30
allow
days
for that.
goes longer.
The law does allow for a little extension, but we need to really exercise caution here, because the extension, so you get the calendar month, the legislation allows for up to another 2 months, so making that a maximum of 3 months to comply. Not being able to get the information off the systems quick enough is not always a reason to ask for an extension, and the ICO take a really hard line on extensions being requested. The data subject has to agree to that extension, so an organisation can't just say, actually, we're not going to make the 30 days, we're going to extend it for another 2 months, so you'll get your request in January.
Oh,
so you have to get the buy-in from the data subject. They can refuse that, and they can say to the ICO, you're not going to comply with the deadline.
Hence why, going back to your original point, it's really good to have a relationship with the data subject. And I guess the people that are dealing with this request typically haven't been involved in whatever reason has caused them to be upset, so you can get alongside them.
Yeah, so it's better to get that relationship with the data subject where you can.
Okay, now we talked, so I said derogations or exemptions. Are they the same thing or are they different?
Okay, so a derogation by definition is basically an exemption from a rule of law. So it is one in the same term.
Yeah.
What it basically is where with some processing, that part of the processing is exempt from the law if you can apply an exemption that allows that.
Got it.
So there are certain things that we can apply to data and say, actually, we don't need to comply with the GDPR here because we're going to add this exemption to this to stop us from having to comply.
So for my benefit, to try and keep this simple, for all intents and purposes for this discussion, exemptions, derogations are all one in the same.
Yes.
Brilliant. Okay. So exemptions are on a case-by-case basis, is that right?
Absolutely, yes. So like my example I just used around a criminal, for example, asking for their information, we have a crime prevention exemption.
Yeah.
So that would mean the police would say, I'm sorry, you can't have your information because we're applying this exemption that's given to us by law, so you won't get your data subject access request. And there are a number of them that are really key. Some more common ones that we'd all recognise potentially.
Yeah.
So it's important that you, before disclosing anything, you look to say, is there any way we can exempt this before needing to share this information with the data subject?
Got it. And then there's two, other than specifics in law which we'll look at, there's two: manifestly unfounded and manifestly excessive. So if we start with manifestly unfounded.
Okay.
What do we mean by manifestly unfounded?
So basically, manifestly unfounded is where a data subject has no intention of exercising their rights through the law. So it's not in the spirit of Article 15. Usually it's where the request may have a malicious intent. So you generally can get a feel for these. It's where someone's maybe very upset with an organisation, and what they're doing is attacking the organisation's resources by putting a huge drain on that, by asking for an excessive amount of information. So that data subject will not negotiate over, I want all of my data. So they're trying to do that to bring an organisation to a standstill, to be malicious towards the organisation. And that's not what Article 15 was created for. This was around giving rights back to individuals and power and control, not around causing disruption for an organisation.
That must be quite difficult to prove though.
It is very difficult to prove, and in all of my years of doing disclosure, I think we may have only won that battle with the ICO twice.
Oh wow.
So it's really hard to prove. For example, we had a data subject request once with a particular client in their social housing sector, where the individual said in an email to the disclosure officer, I will withdraw my data subject access request if you arrange with the repairs people to do something in my apartment.
Yeah.
That was almost a blackmail tactic. That was basically saying, I'm using this subject access to cripple you, but I'll stop doing that if you fix my door, if you reglaze my window, if you recarpet, or you do the plumbing in the bathroom.
Yeah.
And it does get used as a tool quite often, but proving that's really difficult. And in that particular case, we were able to go back to the data subject and say, actually, we refute your data subject access request as manifestly unfounded, because as you've evidenced in your email to us, you're using this to abuse us to get what you want.
Great. And this is often where I know some organisations have a reputation for, this is going to be really hard work, we'll just give them a nominal figure because it's quicker, and that's it. Okay, so that's manifestly unfounded.
Yep.
Manifestly excessive.
And again, this is really, really hard to evidence, because what do you think is excessive? Some disclosure officers think 500 records is excessive. some police disclosures can be 50,000 records.
Wow.
So the ICO will say, well, that's proportionate to the type of information it is.
Got it.
Yeah. So it isn't as simple as that feels like a big number, or we've got files in archive at Iron Mountain, 27 boxes. I think that's excessive. Well, the ICO would turn around and go, well, is it excessive? Because if that person's worked for you for 20 years, you are going to have that amount of data around that individual. You know, so what you think is excessive and what the ICO thinks excessive is very different. And how you prove that, you can't just say, it feels really big, I'm not going to bother with that.
Yeah.
What the ICO wants you to do is to try and narrow down the request. Like I said a moment ago, you know, try and get the data subject to narrow it down to something very specific. And that should hopefully reduce the number of records that would be required. But evidencing manifestly excessive is really difficult. There is a balance, there's a test. The ICO gives us guidance for that. But again, it's so hard to prove. The ICO would say it's not the data subject's fault that you have 27 boxes at Iron Mountain, it's yours.
Got it.
So you need to perhaps look at your record retention and
Okay.
decide whether you should still have all that information.
Okay. And I guess through this, we need to keep in mind it's about, if we're going to say no, or that's manifestly excessive, it's all about whether that our refusal causes further damage to the request of the data subject, isn't it?
And by refusing it and trying to fight manifestly excessive or unfounded takes time, and your clock is ticking. So, you know, if you are going to try and push back and refuse it, and let's say that communication via post takes a week to get to the bottom of, you've lost a week of processing time, and there you're going to start to feel some pressure. So if you think you can refuse a request and win that battle, you need to be absolutely sure you've got everything, you know, all your ducks in a row before you do it, because it's going to swallow into your time.
So it's a real gamble.
Yes, it is, absolutely.
Now, I know we spoke about this before, where excessive can become vexatious, and vexatious was a new word that was coming in, was it DPID, the previous government's attempt?
New Data Act, yes.
New Data Act. Then the draft of the latest one under the current government, it disappeared, but it's back.
It's back, yes. They were going to take it out, but I think the view is at the moment that the ICO has done such great guidance around that. There is such a lot of information around how to tackle that, that actually it made complete sense to leave it in. So it's back. So that's good for us as disclosure officers, because nothing's changed for us effectively. So no fear, because I think there was a little bit of worry around that going and actually having to have a whole new set of definitions, which just muddies the water, I think, for disclosure officers. We take a few years to find our feet with these changes, because actually it's all around the ICO's take on that, and we all have to get a balanced view. So luckily for us as disclosure officers, it stays the same.
Okay, so if we park manifestly unfounded and excessive and go back to the key kind of within law, the exemptions, can you just walk us through briefly? These are the kind of, I suppose, the key ones. We're not trying to cover everything.
Most common.
This is a webinar in itself, this subject, but what are the most common?
So the most common ones, like I said, you know, crime law and public protection. So that allows for us to not release information to someone in a subject access request if it will have an impact on criminal proceedings, for example, intelligence held by the police, or you know, local authorities obviously can apply these exemptions where they've got community protections or ASB type orders. So these are some common ones that we'd all recognise. Regulation, parliament and judiciary, there's some quite obvious ones here, you know, where you would expect court order type information. There's going to be various confidential pieces of information held within that documentation, so we're not going to release that as part of a standard subject access request. Also, there's an exemption around journalism, research and archiving. So we know obviously in the press people's names and information is released, and then that's not protected, because the journalists obviously have a right and exemption to apply where they think it's in the substantial public interest to publish information. Health, social work, education and child abuse. Of course, there's been such a lot of change around that with the historical child sex abuse cases. There is a view on applying exemptions around releasing information to victims of that. So there is a view on whether or not releasing information of something that maybe happened to them 30 years previous would cause them substantial damage and distress today. So we could apply an exemption to not release that to them. Again, there's no blanket approach to any of these. It is really a case-by-case basis, and this is why using good disclosure officers who have the knowledge around this is really important, because they understand the legislation and whether the exemption will fit or not.
There's an awful lot of detail that sits behind this, isn't
Absolutely, yeah. Finance management, negotiations, things like that. We don't release exam scripts, so you couldn't apply the subject access to ask for your son's A-level history exam for a copy of that. Of course, you're not going to get that. Forecasting for companies, you're not going to get that.
Yeah.
You know, so there's certain obvious ones that organisations would apply an exemption to.
Okay, and we're not going to go through these. As I said, this in itself is a completely, this could be the subject of a webinar, but these, just for people's benefits, not as we said, if you want a copy of the slides, put that on your feedback form. But these ones are typically the most commonly used, and we've referred to the specific paragraphs. But what is the most common in this?
I think mostly for me, certainly in my experience, is mostly crime and taxation, or around the third-party information.
Okay.
So the exemption for third-party data. Removing third-party data, for me, it feels like a better blanket approach than taking a risk on not getting consent from an individual. But I think probably the most commonly used one, certainly in my environment, would be crime and taxation.
Okay.
And the removal of anything that could cause any concerns to anything that's ongoing in terms of an investigation.
Okay. And then this one, paragraph 16. Protecting the identity of others.
So third parties, around that. So again, we can apply that exemption when we do redact documentation. By redact, I mean remove certain keywords that's within the documentation. We would apply that exemption of third party. So we obviously use a clever software that would say the reason that this block of information has been removed is because it applies to a third party.
So that's really interesting. Do we have to say why we've removed it, or
we
can
should,
we
yes.
just like?
You need to, the
black
data subject needs to understand what, if you gave someone a document that's got lots of big black blobs all over it, they won't understand why you've removed it. What is it you've removed? And actually that just causes suspicion for the data subject. Whereas if you apply an exemption, for example, legal professional privilege, which is where you have conversations with your lawyers and discussions and negotiations happen. For example, let's say you have to let someone go from an organisation, they get a payout to leave the organisation.
Yeah.
Those negotiations between you and your lawyers are protected by legal professional privilege, which means when that data subject puts in a subject access request, you're not going to release those emails between you and your solicitors.
Okay.
Yeah?
Yeah. And I guess just one thing we'll throw in here, which we've learned as we've done a lot of this, is actually don't necessarily use black, because that's quite aggressive.
Oh yes, black is quite aggressive. Some of our clients hate black redaction.
So you could use blue or whatever, it's a softer colour. Okay.
Yeah.
Question that we've just been asked is also, what about audio or video?
Different media, yes.
Does that fall into this request?
Absolutely.
Is that personal data, and has this got to be redacted as well?
If it's identifiable, if someone's identifiable from it in any way, any identifiable factors, so that could be CCTV, ANPR cameras, social media videos, anything, audio recordings, so telephone calls, recordings between insurance companies, for example, where you're recording individuals and they say their name and maybe some of their contact information. That also has to go through the redaction process. It's still, even though it's a different media, it's not just paper, it's not just an email, anything that identifies someone needs to go through the redaction process.
And I'm assuming if it's a video, you don't put a banner on saying I've redacted this because, is that something you would include a summary alongside it?
When you provide a copy of the digital record, you would provide a summary that says we have applied these exemptions here for these reasons. But yes, I mean, with CCTV, for example, in a busy town centre on a Friday evening, you're going to get hundreds of people piling out of somewhere, and maybe there's been an incident and that individual wants a copy of that CCTV. That's going to take hours to redact all of those other people that are identifiable in the image. And a lot of CCTV these days also records audio, so it's capturing people talking where other things get discussed and other people's names.
Oh, of course, I didn't think about that, but that's personal data as well.
Yes, of course. And you've got to bear in mind as well, we live in a digital age where community protection officers and police officers and people on security on trains are wearing body-worn video. Yes, really common, really common to ask for a copy of that.
Okay, so there's an awful lot that you have a responsibility to redact. I can now understand why run-of-the-mill, quite straightforward, but why you might look at for a third party to help. Okay, so let's just walk through the process and what the process typically looks like from receiving that request.
Yeah, so like we said earlier, you know, obviously receiving it can come in from so many different ways. And we know that once we've verified it, we've accepted that the individual who's made the request has a legal right to do that. They are the right person who they say they are. We need to acknowledge that. So it's about keeping communication up with the data subject. So we've done the ID, we've told them we've got that request, and we're going to set some expectations around what date we're expecting to return it. So if we received it on the 1st of February, I would expect to be having that back to them before the 1st of March.
Yeah.
That's where we get into the research phase. So once we've agreed with the data subject what they want, so I would generally pick up the phone and say, got your request, thank you very much. Can we have a conversation around this? Tell me what it is you really need. Help me to narrow this search down so I can comply and get that information to you quickly. So we've done that, we've established some boundaries, we know exactly what they want now. So then we need to go away and do the research. We need to find that information. It could be in so many places. Yeah. So you've got things like, you know, your obvious ones like your laptop and your emails and your SharePoint and your local drives that you have in the organisation. But then you've got apps on your mobile phones, your work phones, you've got your WhatsApp, you've got your Teams.
It's WhatsApping as well.
Yes. So now this all depends on whether you're using your device for work purposes. The ICO has just released some guidance around this. It's really important that individuals understand now, organisations need to understand that where you are encouraged to use your personal device for work purposes, that device now comes into scope for subject access.
No, really?
So, yes.
Wow, okay.
So if you are talking to colleagues or line managers via WhatsApp on your work device, that is going to come into scope.
Because that's your work device?
Yes. Now, if you are encouraged, if you don't have a work mobile phone, and since COVID, a lot of organisations encourage their employees to use their own devices because we were in quite a hurry to get home working from home. If you have WhatsApp or Teams on your personal device and you're having conversations about another person, so that's their data, then that suddenly your device comes into scope.
So even even as an employer, I'm not saying WhatsApp is a business tool, please use WhatsApp to communicate. I may have said we're not, you know, WhatsApp is not, we use Teams, but if people have then
it filters down into that, yes.
Then that's all in scope.
Yes. Okay. And it's a good quick communication tool. WhatsApp's very quick and efficient. A lot of organisations use that, you know, for getting information out to the community. Yeah. So be very, very careful and just remind your teams to stay professional on all of these apps because everything they've written about someone is disclosable. Okay. And so they need to be aware that when they're typing that, would they be prepared to say that to someone's face before they write it down?
That's a really good point. Okay. So if we just walk through this briefly, yep. When we're supporting organisations in terms of helping them with the redaction, that element of the redaction, so they've verified who they are, they've gone away to do some of that research, yep. What happens next?
So if we were supporting them and they've got their raw data together, they usually generally get their raw data all together. That can be copies of CCTV, copies of emails, paper documentation, it could come in so many different forms. What URM is able to do is we take all of that raw data into our systems, and we have professional disclosure officers fully qualified and trained who have a vast experience in this area. They then start to review the material. This is what takes time. So reviewing the material and looking to see whether we can apply exemptions, going through the redaction process and packaging that all together. This then has to go back to the organisation for them to put the bundle together with a covering letter that explains the redaction that's contained, and then hopefully we've met that deadline and that clean copy goes out to the data subject. We always keep copies back. We always keep copies of what we've redacted, what we've released unredacted, and anything we've withheld because we're saying we can apply an exemption and they can't have it. Yeah. Because they could come back to us and the ICO could ask us to revisit it.
Yeah.
So it's important you keep your other copies.
Okay. So we've covered some of this as we've been discussing, but so just to really clarify, what do I need to include in the response?
So ultimately, the data subject will ask for everything. So we have to consider what's already reasonably known to the data subject. There is no point withholding something that the data subject knows exists or is part of or understands. So that could be a document where, like my example that I said, where potentially there's been a discussion and there's 3 people in the room. There is no point removing information they already know exists. They know who was there, they know what was said. So you can take some consideration around leaving that sort of information in there. They can ask for copies of references, their full HR file, any grievance records, any internal investigations. They can ask for all of that sort of thing. And we need to look to see if there's an exemption that applies so we don't have to give it. If you cannot find an exemption to hold the data back, then you must by law respond and release that information. There is some changes in the legislation with the GDPR around confidential references and how you get those.
Yeah.
The ICO has released a really great paper around this, around where you go to get that confidential reference, because you don't always go to the organisation that sent it, you go to the organisation that's the recipient of that. But like I say, the ICO has given us some great guidance around that. Again, around whether you've got consent for third-party data to be released, and that's all around considering the impact of that third party, considering what would be the impact if you actually did that. So staff names, staff email addresses, because often the email address is their name, rachel.salter@ or whatever it might be. So be careful around some of that, because once this information is in the hands of the requester, you don't know where that's going to end up. It could end up on social media, on community forums, in all sorts of places.
And when can I provide a summary rather than all the specific data, or is that really context?
So it does depend. I mean, a data subject could say, I want to understand the types of data you process about me and who you share it with, in which case you could provide a summary to them. But generally, when a requester puts in saying, I want to see all of the data you have about me, they want to see copies of that. So they want every single email with their name in it, where we've been discussing them, for example, for a promotion or disciplinary or whatever it might be. They want to see that information. Context is really key here. So there is no point releasing information to an individual if they cannot understand, if you've redacted so heavily and they cannot understand the context of the document. Yeah. It doesn't mean anything, and actually that just gives them power when they contact the ICO to make a complaint about that. So be very careful that you still leave some context in without leaving any identifiable factors in there.
Got it. Now we have got a whole series of questions which we still got some more to cover, but I will try and do this all around this whole WhatsApp conversation. Yeah. Okay, so here's a scenario. It's my personal phone, but I happen to have WhatsApp on it that I use it to pick up. It's my personal phone. I pick up emails from work. I've actually got Teams on it, and I've lapsed into communicating via WhatsApp with colleagues. And maybe we've been talking about an individual who is currently the subject of a disciplinary of some description. So how does my organisation even know that I'm using WhatsApp to talk about them? So
that's a good question. So it is a good question, and this has obviously become a really recent issue. In the last 2 years, the ICO has just released some guidance around this, because it's clearly an issue for a lot of companies, and I think this is the fallout from Brexit, people using their own personal devices. And the ICO's view is quite clear that if you are actively encouraged by your organisation to use your personal device for work purposes, then that brings that device into scope. Quite how you define that, that's quite tricky. Yeah. So for example, I have WhatsApp on my work device, I have WhatsApp on my personal device. If I want to discuss work, I pick up my work device and I talk about work through WhatsApp. Got it. But I'm very careful, you know, obviously if I'm going to use my personal device to discuss anything via WhatsApp with maybe a friend and a colleague, I don't discuss other staff members in there.
Great. So the key thing being, the key point being, okay, it's about if you are actively encouraged to use that device. Yes, okay.
That's the ICO's stance on it, is how if you are actively encouraged to use your personal device. But a lot of organisations don't provide a mobile to the role. So they are, for example, if you need to do an authenticator to log into your systems to dial in, for example, and you need to use the authenticator app for Microsoft, your organisation is actively encouraging you to use your personal device for work purposes.
Yeah,
immediately.
And probably not one to get into now. I guess most organisations would argue that is merely to authenticate, not to actually do anything on that. Yeah. And then we get into, and again, you know, in the interest of time, you've then got, if as an organisation, I suppose you can ask somebody, have you discussed on there? And if they say no, you haven't got the right to grab their phone off them and go through it, have you? If it's a personal device. So there is this.
Yeah, it is. It's a really, really grey area, and I think we're waiting for some case law on this. This will be really interesting, because at some point it will come out that individuals are using their personal devices for more than they should be. Yeah. And obviously the organisation is quite happy to let that roll until something goes wrong. You know, there have been recent cases where prison officers have had discussions around prisoners on a WhatsApp group, for example, and that's now their mobile phones have been seized on the back of that. So you've got to be very careful about that.
And I guess this probably comes back to build a relationship with the data subject, because the requester, because if they can say, I believe there's been conversations on WhatsApp about,
they usually know why and when.
You know,
they usually know. Yeah.
Just we've got 10 minutes, we've got more questions to go, but just a high level, post-disclosure issues, what are the typical post-disclosure issues?
So most organisations think once they've pressed that sent email and they've sent all the covering letter and the bundle to the data subject, they can close the request, breathe a sigh of relief, it's all finished. But very often you find once the data subject has received their bundle and they've spent time reviewing that and reading it and scrutinising all your redaction, that they have a ton of questions. They often push back. And generally they're coming back because they're going, I know something's missing. Yeah. I know that there was something else. I know there was a conversation around my role. I know that, you know, there's more to come from here. I was involved in this particular, why is that not in this bundle? You've got to be very careful. Don't deliberately omit something because you'd be amazed at what the data subject knows has happened, you know, and what they're familiar with in the organisation. They also know the places that you store information as well when they've worked there. So don't try and trip, you know, to hide things, you know, because they'll trip you up with that when they know. So always saying that this information missing or omitted, sometimes that's a little bit of paranoia, but very often they know something's missing. Also as well, they could at that point say, okay, so you gave me this information I asked for, I'm going to change the scope of the request and suddenly I want this, I want to change the dates that I've asked for. Yeah. I want you to now look at another 7 email accounts where I think these people have been talking about me. And that could become a whole new request. So depending on that, can depend on whether the clock starts again and whether we're rechecking that. Obviously the data subject, if they're unhappy in any way at all, they are reporting you to the ICO. Yeah. So you're going to get a letter from them or an email from them.
Okay. Most common failings.
So organisations not recognising a DSAR, huge one. That's where an individual maybe knows someone in an organisation, knows their email address, they've maybe had that relationship with them, sends them a request, and maybe that individual doesn't really recognise it for what it is, isn't sure what it is, so it's just sat in their email. And until that data subject says, where's my request after 30 days, nobody even knows it's in the business. Yeah. So that's a really common one. And like we said at the very beginning, a huge problem for organisations at the moment is failure to disclose on time. Yeah. That 30 days is really tight. It's only 20 working days at the end of the day, and you've got your job to do too. So it is a really tight time scale. But failure to respond is quite common, which is why the ICO is all over it. Validating requests. Like I said earlier, a lot of data subjects think this is a stalling tactic. Please don't do that. It's really important you don't use that to try and swizz another 3 or 4 days out of a data subject. Okay. Recognising vexatious, we touched on that. Really hard to prove, but you know, if you can sort of see through there a little bit into the context of an email, maybe where you can see, well, actually this person, what they really want is this repair doing in their property. Yeah. So why don't we just get that done and let's get rid of this DSAR. Yeah. So understanding and spotting that. Don't omit anything from the bundle. Do not hide anything. Do not say that document there is going to cause us reputational damage. Let's hold that from the bundle. Let's hold that back. Don't do that. That's actually an offence under the GDPR, and it's actually an offence. So the ICO is going to fall on you like a ton of bricks. So make sure you apply the right exemptions. They're all quite obvious. It's about common sense as well. You know, and don't over rely on exemptions. Don't think you can apply lots and lots of exemptions to just stop you from having to comply.
Okay. And just to sum up, so the top tips when we've gone through this in terms of easing the burden is make sure your data is structured in the first place so you can search it. If you've got 30 days, you've got to be able to grab that information quickly. Delete data when it's no longer needed. If you don't need the data, don't keep it. Because if you keep it and someone asks for it, you've got to provide it.
Absolutely.
Okay. I suppose understand your data flow, so know where your data is. One of the things that trips you up in terms of response time is, where is this data? It came in from here. What have I done with it? You've spoken a lot about this. Understand context and reach out and communicate with the data subject. And I think this is where a lot of organisations approach us, sometimes only just to have that relationship with the data subject. Make it one step away.
Yeah,
look,
we're very independent. It helps. It helps because usually there's a sensitivity around a DSAR. People feel very passionate about something, they're very upset or hurt by the organisation. By putting an independent person in the middle, they feel they're getting a fair service and that it's being done as a proper process. So that does make a difference.
And in that, you can also narrow down the scope.
Yes.
And be specific.
You can negotiate with them usually.
Make sure people understand what it is. The number of organisations we've worked with where somebody thought someone made a comment in passing at a reception desk, didn't recognise it. When they have recognised it, you're up against it. And I guess know when you need an expert. There is a real benefit using experts that are going to save you time, effort, money.
Definitely time. The experience will save you time.
Teach your staff in the process and help out. Okay, we have a whole series of questions. All of the questions that have been raised, we will reply to all of them, even if that means we respond to you directly, because we've got 5 minutes, and there's quite a few questions that we've had. Some of them we've answered as we've gone along, but what if a person asks information about a deceased person, so such as their wife or son, but they're dead? Are they still?
Yeah, that's really interesting, and we get quite a lot of that. So the GDPR only applies to a natural living being. That's the actual translation. So effectively, GDPR does not apply to someone who's deceased.
Okay, so you don't.
There are other ways to apply for information, but you're looking at court orders and different things like that, but it will not come under GDPR Article 15, no.
If you're the data processor and not the controller, and you get a DSAR, what do you do?
Okay, so that depends on your contract with your data controller. What I would expect to see is the data controller has put a term in that contract with the data processor that says that you will aid us in the event of a DSAR. The data processor needs to tell the data controller immediately that they have that, so that the data controller can validate it and acknowledge it. That does happen quite commonly, because often the data processor is the doer, so that's what the end client sees as a person's name or an organizational name, so they go directly to them, and then they have to go to their data controller and say, we've received a request on your behalf.
Okay, if there's conversations via email relating to a customer where maybe their name is used but then has the opinions of the email author, do they need to be included if they're about that customer, or can be reasonably assumed to be about that customer?
So opinions are completely in scope for a DSAR. So where someone casts an opinion over someone and you are identifiable from that, that is data pertaining to the data subject, the individual requester. So that is in scope. And this is why I said earlier, please be very, very careful about remaining professional when you are saying things about individuals. What you have to be able to identify, though, and this is really critical, is can the individual be identified from that? So if it isn't their full name or it's a set of initials, you have to think, if this was released to someone who knew nothing, can we identify the person from that context of that email? So for my initials, for example, RS today was really lazy and took 3 hours for lunch. Am I identifiable or not? And that depends on context. It depends on in whose hands that information is in. So opinion is there, it is in scope, so you have to be very careful about remaining professional when you're giving an opinion on someone, maybe the way they dress, maybe the way they look, maybe their hair, maybe their performance in the office, maybe their late times arrival in the morning. Be careful about that, because that is information pertaining to that individual, which means it's in scope.
And typically, a lot of the requests that we've dealt with, that's the information people are after, because they know
they want the juicy stuff.
Yeah. Another question, can you expand on reduction? So if an email's gone to a broadcast group, do you have to supply every single copy of that email, or can you provide the one email, mention job titles of who it went to?
That's a good question, because emails as well, when they're sent out en masse, often digress and get replied to, and they go off in various different directions. So for example, for us as disclosure officers, when we're redacting emails for a client, and let's say there's 10 or 15 versions of this email chain, we would try and find the eldest, trace it back, so we're only ever going to provide one copy of that.
Got it.
When you do your email searches on systems, if that email went to 15 people, you'll get 15 copies of it on your searches. So be careful about duplication.
Got it. Now, there are a whole host of other questions. As I said, any questions that have been raised today, we will respond to you after this. 2 ways that we can help immediately after this. We are running a 1-day training course. Rachel will be delivering this. There's an offer price for it. We are going to walk through managing the DSAR for an acknowledgement to completion, the do's and don'ts, exemptions, derogations, communication, and dealing with ICO complaints. What we do on the course is provide you with some example documentation, ask you to redact that and cover that with you. We also get asked an awful lot to do this. We're offering a half-day workshop where we'll come and look at your process. We'll come and understand what your process is. Is there anything you're missing? Are you perhaps making it more complicated? How can we streamline that? How can we deal with requests, the ICO? So both of theirs are there, and also URM are here to help you. If you've listened to this today and think, oh my days, I'd really welcome someone like Rachel or a member of Rachel's team working with us. Maybe not all DSARs necessarily, maybe some of those more complicated, vexatious, demanding ones. We're here to help you. We've got an event. Next one is penetration testing for cloud native organizations. Have you put all your stuff in the cloud, and what should you be testing? Rach, I can't thank you enough for being here today. I know we've taken you away from clients, dragged you away from the snow. So thank you very much indeed for coming. To everybody that's listened today, thank you very much indeed. It's been a pleasure delivering this. Thanks for your time.